How does the CHRC's complaint process work? Usually, the CRHC follows 3 steps to settle a complaint. Before your formal complaint is filed, a discrimination complaint begins with your phone call, letter, or completed discrimination assessment form, explaining why you want to file a discrimination complaint against an organization or person. Then the CRHC will inform the organization or person about your complaint. The CRHC might try to solve the complaint over the phone or through written messages such as letters. This is called early resolution, which means the complaint is settled quickly without any meetings. If that doesn't succeed, or if you or the organization don't want to use that method, then the CRHC could set up a meeting with you, the organization, and a CHRC officer. This is called mediation. In early resolution, all information is recorded and kept in a file. In mediation, all information is confidential. It is important to understand that the CHRC is neutral throughout the process. This means that it does not represent either you or the organization you are complaining against. Its role is to try and help both of you and the organization to find a solution that respects your rights. Both early resolution and mediation are voluntary. No one can force you to participate. If the complaint is settled through early resolution or mediation, the file is then closed. If the complaint is not settled through early resolution or mediation, then the CRHC will send you a complaint kit. The complaint kit includes forms and instructions for filing a complaint. You are responsible for completing the forms in the complaint kit and giving them back to the CHRC. Step 2. After your formal complaint is filed. Suppose early resolution and mediation do not settle your complaint, and you send your formal complaint to the CHRC. The CHRC will do 2 things. Notification. First, it will inform the organization you are complaining against that you have filed your complaint. Second, it will decide whether or not to accept your complaint. The CHRC has to consider many things. Is your complaint a federal concern or a provincial territorial concern? The CRHC can only accept complaints on federal concerns. Are you complaining on one of the 11 grounds of discrimination? If not, the CRHC cannot accept it. Is your complaint about a discriminatory act or behavior? Could your complaint be settled another way? For example, maybe the other party has its own dispute resolution process. Is your complaint serious, or is it just silly? Or mean-spirited, or not truthful? Have you filed your complaint within 12 months of the act you are complaining about? Maybe you feel afraid to file a formal complaint. You might be afraid the other party will get mad and do bad things to you if you file a complaint. If they do that, they are breaking the law. You can file another complaint against them. You might also be able to inform the police about them. Be sure to write down all the details about their bad actions, including dates, times, places, and the names of anyone who saw it. Mediation. If the CRHC decides to accept your complaint, it might suggest mediation. If early resolution and/or mediation were already tried without success, your complaint might be sent directly to investigation. Remember, mediation is voluntary. You don't have to accept it, and it's confidential. It gives both you and the organization you are complaining against a chance to explain their story and understanding of the story, and then tries to find a solution. Like the CRHC, the mediators, the people who coordinate the mediation, are neutral and do not represent you or the other party. Mediators know a lot about human rights laws, and they can help everybody understand what the law says about the situation. If the mediation is successful, then both parties must sign a settlement agreement. This is a written statement that records what you and the organization have agreed to settle your complaint. This is called reaching a settlement. If mediation is not successful, then your complaint will be investigated. Whatever was said during mediation cannot be used against you during the investigation. Investigation. An investigator is a person who works for the CHRC and has special training and skills in investigating complaints. During the investigation, the investigator will talk to you and with the person or organization you are complaining against. The investigator will interview any witnesses, people who saw or heard the actions you are complaining about, review any evidence, and write a report. This report will make one of the following recommendations: that your complaint be dismissed, rejected, or that your complaint be sent to conciliation, negotiation, or that your complaint be sent to the Canadian Human Rights Tribunal for more examination. The investigation report will be shared with you and the other party. You will both be given the chance to make written comments on the report. After the investigation, the CHRC will read the investigator's report and any comments made by you and the other party. Then the CHRC will decide if they will accept the investigator's decision or if they will make a different decision. Step 3. After the decision. Remember, there are 3 possible decisions. Reject your complaint, or send your complaint to conciliation, or send your complaint to the Canadian Human Rights Tribunal. What happens in each of those decisions? Let's take a look. Dismissal. If your complaint is dismissed, that is the end of it. No action will be taken. Conciliation. Conciliation is the same as mediation. The only difference is that conciliation is required. It is not voluntary. Both you and the other party must participate in conciliation as a final attempt to settle the complaint. Conciliation is usually limited to 2, 3, or 4 months. If the complaint cannot be settled in that time, it will either be sent back to the CHRC for more examination, or it could be sent to the Canadian Human Rights Tribunal.